Hello everyone, hello revision, hello people on the internet. I'm netpoet and I'm here today to talk to you, with you ideally, with the people in the crowd that are very difficult to see for me, about AI and law and what we can do about it. For those of you who don't know who I am, I'm a lawyer by profession. I do data protection stuff, have done for a long time, and you might not have at all noticed that I haven't been making a talk for a while because I didn't really know what to talk about, because data protection has been here for a couple of years, and it's sort of, I feel like a lot of discussions that we've had have been had, and there was little new to present. However, now we have a changed situation. We now have LLMs that basically have the potential to bring a lot of rumpus into old discussions, create new ones, and also, again, tempt us to question a couple of things that we thought as given. And it might sound a little cryptic at this point, but I promise to go into details in a minute. So I was wondering what to talk about when it comes to AI and law, because there's a lot. There's tons of things that are currently being discussed. And just so you know, copyright law will be one page on this. It's not my focus, because I know a lot of people have approached me on the here at the party about questions like that or related to it, and I've been thinking about what to say about this. So here are the things that I would like to mention today, and remember that I'm at the party. Please approach me whenever you feel like talking about it. I do this for a living, but I also truly enjoy this because there's tons of stuff that I don't know yet. So here's what I came up with to talk to you, with you about. First of all, I think it's important to get an overview of what AI law is. So obviously there is a EU AI Act. I think most of us have seen that. Then the promised short note on copyright law, what AI does with it. But specifically, I would like to mention the AI Act, how it's structured, who it's for, who has to do stuff, things like that. And then the stuff that I've been doing for a long time, data protection, and how AI can make things more complicated than before. And one of the things that are also part of the AI Act really is the AI competence. So I'm not sure if you've heard that a lot of people, a lot of companies have to have this at their company whenever they use large language models. So what is that? So I'd like to discuss that with you too. And we can do this as extensively or quickly as you like. We have 1 hour, so I'll try to keep it at 45 minutes, and then probably not everything will have been answered, so approach me after the seminar. I will be here. So I think what's most important is to determine any of the legal questions is what are we actually talking about. For the sake of this seminar, I'll sometimes say AI, sometimes I'll say a large language model, LLM, stuff like that. So for the sake of the seminar, I will use this pseudonymously. So I know it's not intelligence, it's just for the sake of this, let's keep it simple. And this is the best explanation that I've ever seen anyone give when it came to describing what an LLM is. A stochastic parrot. And I mean, in this audience, it's probably not necessary to mention it, but for the sake of the internet audience, I will do so. Why a stochastic parrot? Well, because an LLM usually is, I'll simplify this, and it's probably mathematically incorrect, or at least imprecise, but for the for the sake of understanding. What it is tons of data ripped apart into tiny little tokens that will, when used correctly, produce results. But it will basically be hallucinating stuff out of the tokens with the vectors that it has learned. And so it'll be like a parrot just repeating stuff that it thinks is correct. And stochastic, because there is a mathematical model behind it that I don't understand and that I could never create, but that makes it create this process. And I know there are tons of ways to do this, but just for the sake of understanding, we have a couple of things that we should take into consideration also when it comes to data protection, copyright law, information security, all the things that you could think of when you want to use this in a company. You have training data, meaning the data that goes into this, so it can produce any tokens and results. You have input, meaning the prompts that you put in, the demands that you make towards the model. Then obviously you have the output, something that comes out of it that you want to do something with or that is what you want. And also we have interaction data. So the data that the model receives or the provider of the model receives whenever you interact with it. And this is, I think, this is important to understand because now I think there are even better ways to do this, but just for the sake of this, I've now scattered areas of law across this map just to give you an idea what can play a role whenever you deal with AI. You obviously have the AI Act itself, and I placed it on top of the parrot because whenever you provide a model like that or you want to use it, that is obviously something you have to take into consideration. And then stuff that I've been doing for a long time, data protection, it plays a role obviously in the training data, meaning is it okay to use personal data for training? You also have it in the input. Am I allowed to use personal names when I interact with it? Am I allowed to put personal data into a model? And it goes on like that. The output, if something personal comes out of it, is that okay? Can you use it for things? And also, personal data plays a role in the interaction. So if you interact with a model and the provider, let's say OpenAI, uses it for training purposes or to figure out how effectively the model works, that plays a role there too. And then it goes on like that. You have copyrights on the upper left side, meaning is it okay to put copyrighted material into a model? A lot of lawsuits are going on about this. Some have ended, some haven't. Then are you allowed to put copyrighted material into a model? Same way, is it okay to, what about copyrights that come out of a model? And I think I'm not putting, interaction data, is this copyrightable? Well, you get the idea. And then it goes on with information security, both in the input and in the interaction data. I didn't put it here because I thought, well, if you have output, then it's up to you what you do with it. Same way, NDAs, meaning non-disclosure agreements, if you have contractual obligations towards customers or suppliers or whom not, that you are not going to use it in a different model or in a Same here in the interaction data. If you, let's say you have a business report that is still confidential and you toss it in and say, hey, please give me the 5 key facts of this report, will the data go to OpenAI? I'm using OpenAI here just as an example, but I think you get the idea. Is that okay or not? Have you been contractually obligated to not do that? Same way, contracts with clients, same input, output. And so depending on the industry, depending on the actual case, there's more to do. I just think this helps me figure out pitfalls to avoid whenever people approach me, which happens quite regularly. Can we use it for this? Can we not? Stuff. So we have AI law. What is that? The AI Act, obviously. We have GDPR, quite obviously, or not. Is it? I'll look into that. Obviously, we cannot talk about all the idiosyncrasies of every law, but I will try to come up with a couple of thoughts that you might not have had for this, to give you an idea of where we can go from here. Because it's the title of this seminar is Round 1. We're not done. I mean, we're at the very, very beginning of figuring out what to do with this, and I'm hoping to give a couple of people some ideas how to deal with it and where to take it from here. But copyright law, sure, plays a role, because we humans are very used to doing the mine song, and what AI does with that, obviously. But really, AI is reconfiguring a lot of areas, and I'll give you a couple of examples in a second. And this page is probably not very important here. I include it anyway because for some people in audiences, it's not as self-explanatory as you might think. LLMs are not intelligent in the way that they are self-conscious or that they have an actual way of doing things that are beyond the stochastic model that they're programmed to do, unless, of course, you extend them with other functionalities, but LLMs themselves are not. They're not self-aware either. It doesn't matter how well, and they're very good at it, how well they tell you things or how much they tell you about how self-aware they are. It's just all made up. It's hallucinated. They're also not able to reliably evaluate factfulness. So you can ask 100 times, is this actually true? And they can say yes, and it means nothing. Just expect it not to be true. Expect it to be a stochastic approximation of true. And also, and this is, I think everyone in this audience knows this, some people don't. It's not a program that you can alter in detail like a traditional algorithm where you have a program and you can disassemble it, or you can look at the code and go, oh, where did it go wrong? And you go, oh, okay, the value, the variable had a different type or something. You cannot do that, and that is part of the source of a lot of problems that we also have in data protection and transparency and explaining how a certain result came to be. And also, the same way, they're not transparent regarding the mechanism that produced a certain result. And so, whenever you look at, or whenever I have to think about, is it okay, or is this legally viable, or how should we approach this? It helps me to figure out these things. First of all, what data was or is used for the model? What input do we make? What kinds of data do we put into the model that had probably previously been trained? Also, what types of data does the LLM provide us with, and what do we want to use it for? And I cannot stress this enough. Currently, in our company, I didn't say this right. I have a job at Convista in Cologne. We do SAP projects. I used to be self-employed only for many years, and I'm very happy to be part of a team now. And so we are currently looking at introducing Copilot with access to data in our Microsoft tenant. And I'm asked what can we do? And I say, okay, well, what do we want to use it for? And I have been told stuff like, well, read the Microsoft documentation. And I go, yeah, that's not really it. I mean, you can, of course, I can have a look at what Microsoft says they'll do, but if you take output out of something and you want to use it for certain purposes, that might be okay or it might not. It's like asking, I'm not sure how well this translates to English, but it's like going into a car dealer store and you ask whether the car that you're looking at, which is really beautiful, will keep the speed limit. Like, it could, I mean, it can go slower than the allowed maximum, but if you drive quicker, then it doesn't. It's not up to the car, it's up to you, I mean, at this point. If we have the same seminar again in 10 years or 20, who knows, it might be different. But, right, so what I'm trying to tell you is the responsibility also lies with the company, with you, if you want to use a model. And so I question things like, what do we want to use it for? Also, what data do the operator of the model and any other third persons use? So if you don't run a model yourself, but you are with a big provider or a small, like which data do they take out of this? The interaction data, stuff like that. And also this is a very data protection centered question, what consequences can this have, in parentheses, halfway realistically for the data subjects? And also, of course, how are the systems run? How are they secured? Who operates? Stuff like that. So this is basically like a mental checklist that I try to go through when I assess the validity, the legitimacy of running a model. So, and here's the short note on copyright law. I know a lot of people are really interested in this, and I'd love to give you better ideas, but here's my take on it. And I'll try to keep this quick, and we can discuss it outside if you want. So, a couple of things are kind of clear. Anything that is entirely created by a machine cannot have copyrights. Not in Germany and not in any other country I know. There might be different countries and law situations, but this is pretty much consensus. But and of course, so just to be clear, so if you create an image, for example, or a text, anything that comes out of an LLM, and you use it as it is, you don't have copyright on it, and neither does the provider, because it's machine-made, it's hallucinated, it's parroted up. So, but we wouldn't be demo sceners if we didn't know what else, that we can use it for different stuff too. And I know that there's a lot of rumpus going on about, discussions about how should rules in the graphic competitions be made. Not at all my topic here. I can't really help you. All that I can tell you is probably in 10 years or so, everyone will use AI to some degree, and there won't be a gap anymore between people who don't and people who do, but it'll be like a pocket calculator, and nobody's going to look back and go, oh, people cannot divide manually anymore. Like, everyone's going to do it. It's just a matter of time, I think, but I might be wrong. Who says? Who knows? So, but in the long run, I think AI will be fathomed as a tool for creativity, because I think that's just what it is. It does stuff, and it probably doesn't solve your problem right away, but it'll be a tool. It'll be, I don't know, like a paintbrush in Photoshop or something. I mean, maybe there is even something like that yet. But so when used as a creativity tool, however you like it or not, I think if the threshold of creativity, when once taken, has to lead to copyrights. And I know I've read a couple of court rulings that denied copyright even when the artist had 400 steps doing stuff manually too, and they just said no. I have read these things. I don't think that these will hold up. But it happens. It's courts, it's humans, they make errors or they don't understand, and we need time. And of course, as we're talking about a worldwide phenomenon, we have courts all over the world. Germany has, by large, the absolutely the biggest number of courts, but still, any court has the freedom to choose. So this is where I'd like to leave it for now, but I'll be here. So, AI Act, quickly. And of course, all this is AI generated too. I'm not very happy with the images, but you know. So, AI Act, what is it? It's an EU law that deals with who has to do what, when using AI. And I will keep this quite general at this point because I think going into too much detail is not going to be much use, but just so you understand what it means when people talk about the AI Act. So it is theoretically in force, part of it. Some parts are not yet. The main stuff happens only from August next year on. But some chapters, like the forbidden AI practices, stuff that is by all means forbidden in the EU, or the AI competence, I'll come back to that in a second, or a couple of chapters about how sanctions work and confidentiality and stuff like that already apply have been applied since February this year. And then some other stuff is going to happen even later, especially classification rules for high-risk AI systems. And so you can, and if I'm not mistaken, you can also download this presentation if you want, but you can also just Google the IAPP cheat sheet for the AI Act. You will find exactly this. This is just a reproduction of it, and I think this is quite nice to understand how it's basically set up. It consists of stuff like what is an AI, what's generative AI, that it has a risk-based approach. This is important to understand because they basically classify AI systems depending on their risk for the concerned people. And you will also find this list saying what's prohibited and what's high risk. So everything on the left side obviously is prohibited. It starts with social credit scoring systems. I think a lot of people might think of China to begin with. I once heard, without really being able to assess it legally, that there's a common misunderstanding about how social scoring systems work in China, but regardless of that, a couple of things I think we can all agree on should not be done in the EU, and they leave it at that. For example, untargeted facial images for facial recognition, or specific predictive policing, law enforcement. I mean, we don't want AI to issue court rulings. I think we can all agree on that. And then there is some high-risk stuff that you see here, starting with, I don't know, medical devices, or we don't want vehicles yet to drive on their own. It's not prohibited, but it just means that it's high risk, meaning some stuff has to happen. What you don't see in this list is anything that most of you know AI from, like generative AI, image production, or text production. One of my clients approached me a while back saying, "Hey, my app to do how do you call it? Smart home lights, smart lights in certain color scenes and everything. I'd like to use like an AI routine in the background that would come up with suggestions for colors for certain scenes. What do I have to do?" I basically said, nothing. There's no risk involved. It's not high risk. It's really nothing of any sort. So they don't really have to do much. And I'll go into a little bit of detail with this, but basically this describes the basic principles quite well, I think. So transparency obviously is very important. Whenever AI is used, the EU, want to let people know that it is used and that no human came up with this. And then obviously you want a risk management. Whenever you have high-risk systems, you want to make sure that people can tell you that something is wrong and that you can react to things like that. Most of the stuff, I think, is quite self-explanatory. And here, for example, here it is it's mentioned generative AI, individuals must be informed, but it's all basically the prolongation of the stuff that you've already heard and seen. So, and I'll just finish off with the fines. They're even a little higher than the GDPR introduced them. I remember how we had difficult arguments about how it was too high, and the AI Act goes beyond what the GDPR introduced. And so a lot of stuff is still unclear. For example, the European AI office doesn't exist yet. There's going to be an AI board, and all that is still in the making, at least to my understanding at this point. So to this point, when I saw this and read it, I thought, it's not as bad as I thought it would be. Because a lot of people talked about how the EU, with this act, had destroyed the AI community or AI development in the EU. And I understand that regulation makes stuff more difficult, obviously. I mean, it always does. But I don't think, personally, I don't think the AI Act has destroyed AI in the EU. But also, I mean, at the same token, it doesn't allow just about anything and everything. I'll leave it to you to think if that's good or not. Just one thing, because it might come back. Most of you or most companies don't care for this at all. This is basically a thing for public bodies and certain banks and insurances. But there is something that some of you might know from data protection already. There is something called a fundamental rights impact assessment, and I will abbreviate this in the coming pages as FRAI. And this is just something that you might have seen on one of the previous pages. It says that whenever you, in very specific situations, bodies using AI have to perform this assessment. And it's basically just public law bodies, so authorities. It's not private companies. And I'll keep it as short for the time being because I don't think that's much interest to you. The only way that private companies have to do such an impact assessment is for banks and insurances in very specific cases. Whenever, for example, they want to use AI to assess creditworthiness of a natural person, meaning do you get a loan, when an AI determines whether you get a loan or not, or if, for example, your life and health insurance has different tariffs depending on AI. We want this to be done by humans, not AI. Yeah, and so, and such an impact assessment makes, I think it makes perfect sense the way it's set up. It means you have to describe, if you ever have to do that, whenever you have a high-risk AI system, you need to describe how it works, what frequency and period of time you want to use it, also what types of persons and groups are targeted, what risks are involved, and how are you going to face them and mitigate them. If this sounds familiar to you, it might be because you know that something very similar exists in data protection. It's the Data Protection Impact Assessment. And it's true, it's basically the same thing. But just, yeah, okay. And here's something that I would like your feedback on. I'm not quite sure if we have time for it. I'll try to keep some time for it. And that is AI competence. Here's something for you. In the AI Act, it says that companies need providers and operators, meaning both the OpenAI people and you, if you as a company want to use it, we have to take measures to ensure that their personnel and other persons involved have a sufficient level of AI competence, meaning the skills, the knowledge, and understanding to enable providers and so on to use AI systems in an informed manner and to be aware of the opportunities and risks. obviously people have approached me saying, okay, what do we need to do? And I went, okay, what do we need to do? So here is my suggestion that I'm happy to discuss with you if you have different ideas. Also, I mean, the people in the stream probably can't hear it, but if you just scream at me if you think, ugh, I need something's missing. So here's my take on it for the moment. I think it's important to make the staff, the people who use it, understand how LLMs think, that they're tools and they don't make decisions. They prepare decisions at best, and it's not knowledge that they provide. It's probabilities. It's approximation of knowledge. It's basically, a lot of people have said this, so it's probably true. Also, we need to make people aware of the fact that training material, as neutral as it can be, still creates biases. There are countless examples of this. There used to be. Have you ever heard of the racist soap dispenser from Japan? It's like that. You know, they're trained with different skin, and so people with a dark skin want to get soap, and it looks like the soap dispenser is really racist, but it just doesn't recognize the hand as skin. And it's really important to check facts and sources whenever a statement is made. Also, so this is to understand how it's going. Also, we need to teach people how to use prompting in a targeted manner, not just throw random shit at an LLM, but to establish at least basic prompting skills, including, and I think this is really important, the skill to tell a good story. Why? Because I think telling a story is very essential when using LLMs, because it'll give the LLM a context and tell them what you're trying to do. You know, the application scenario that you have is in your head, but it's not in mine when you talk to me, and it's not in the LLM, unless it's what everyone else thinks too. Then that might suffice. But if you do anything out of the ordinary with it, that won't do. Also, I think it's very important to ask clear and context-rich iterative questions. Don't stop at the first result, but refine whenever you think this isn't great yet. Also, and this is something that's more from a legal compliance perspective, don't put any sensitive data into the model without legal review or without a rule for it that you can. If you have a directive at your company that allows you to do exactly this, then you're good. Other than that, I would never put anything sensitive in there. And the question that I sometimes pose people is, would you be okay if what you just put into this model were published in a second? Like public for everyone to see. Would you be okay with that? When the answer is yes, then you're probably okay to do it. Other than that, you just need to be aware that this might involve a risk. Meaning, if you have sensitive data, anonymize whenever you can, like erase customer names or staff names, whatever. And I think this is as easy as it is sensible. Always expect something to be wrong. If it's not, you're good, but if it usually is, expect something to be wrong. It's like a Wikipedia research. It's great to start your work, but it's very bad to finish it off with. Anything else that you can think of at this point that you think is essential? Like, just scream at me if you have anything. Okay, okay. The question is, when you ask it to produce software code, should you know what it could theoretically do, or are you good not? Good point. I think it is, yeah, it would probably, well, really, I mean, if you follow this through, then you could really not create any code with it because, you know, I mean, theoretically, anything could happen at any point with any type of code. If you don't understand it and run it blindly, stuff could happen, sure. But what's the rule that you would follow? Okay, because I wouldn't really know what to do with it at this point. Okay. Anything else at this point?
I have a concrete question. Just like, if you just imagine, just like you can do everything you want on the internet, where the legal implications come to that?
Sorry, the question was if you could do anything.
Because you can do anything on the internet. Anything.
In the internet?
Yes.
Are you joke? Is that a joke? Martin, are you okay? Like, if you could do anything on the internet, then what? What?
Yeah, this would be my legal question, though.
Let's do that in the courtyard, okay? Because if you could do anything on the internet, that would be really amazing and probably really bad for the internet. But okay, okay. I think that okay, go.
So we have a lot of AI bros right now who
Speak up, please.
Oh, sorry. We have a lot of AI bros right now who have this concept of vibe coding. They think that okay, I don't know coding, but I don't need people who do the coding for me.
Yeah.
So instead, they just ask an LLM to do something, and this begs the question on two sides, on two fronts, which is first copyright, because can you have or can you sell the product that you produce using this code? Is it even legal? The copyright clearly doesn't exist for this because it's purely AI generated. So what's the situation here? And the other thing is who is being held accountable if the code is being created by a model completely, and even the guy who created the code doesn't know anything about it. And how does the situation change if someone tells, just comes in and says, "Okay, I will now fix your code for you, but given a legal fee or something."
Okay, two questions. I think the first question I tried to preemptively answer. If you use a model to create code, the code itself on its own alone has no copyright. If you take it further and then do something with it, there might be a copyright threshold that you have to take, and if you do, then it'll be your copyright, and if you don't, it won't. So it's a tool that you can use to create a work, and if you just don't manage to be as original, and you don't take the threshold, then you won't have any copyright, and if you do, you do. The second question is who's accountable for something that you take out of it and market, for example. Let's say I'm a company and I create software code out using AI, and then I have my cleaning people because Oni told me this term just an hour or so ago, that now it's like one of the jobs that are given, the types of jobs that are given to people is like cleaning up AI stuff. So it's like cleaning personnel, it's like cleaning staff. You're not a software developer anymore, you just clean up shit from LLMs. So let's say you've used that as a tool and then you create software code and you market it. Then I think you're just accountable the way you used to be. If you take output and you market it, then it's your responsibility for stuff to work in the sense that you market just like any other company would. It's a tool. You just didn't divide by hand, but by pocket calculator. So it fundamentally is the same, in my opinion. So we're not really at the discussion part yet. Is there anything else that you think is essential for competence? Stuff that people should know, stuff that you should teach your staff when it comes to LLMs? Thank you.
On? Excellent. when I talk with people about the results of AI, when I talk about results of AI content, I told the people to think about media competence, not AI competence as specific,
Okay.
because information, we have the same discussion with Wikipedia. Is the information on Wikipedia right? Is the information on the news right? And is the information
True.
of AI right? So we have to think about media competence, and this is a new information we can generate out of the whole information that we have.
You're completely right. I have completely omitted the whole, can we figure out what's AI created and what isn't? Because I think it's a massive topic. But you're right, thank you. Okay, so I would like to proceed and let's get it over with so we can actually talk about stuff and go, and go to the data protection part that, by the way, it's really difficult to, have you ever, if you ever manage to create a data protection themed image without a lock, please tell me how you made it. You can't, well, you can't, if data protection is in, there's always a lock in it, so I had to use a completely different prompt for it. But anyway, even the model, you can point at the model saying, hey, you can see there's still a lock in it, right? Oh, I'm really sorry, here's your new version of the image with a lock. But anyway, okay, so data protection, there's a whole new challenge approaching us, and I'll try to keep it quick so we have a couple of minutes for questions. But just, what is AI and what does it do with data protection and how do we face it? So first of all, regarding the content, there's a couple of things to consider. First of all, like who's responsible for all this and for input and output, but this is more of a planning phase thing for companies, but also the legal basis for all the things that we talked about. I'll come back to the parrot image in a second. Is it permitted to use personal data in this AI service for training, for input, for output, for interaction data, stuff like that? But also, and this is something that a lot of people miss completely, as if it didn't exist, as if it had never existed in data protection. Anything personal data related has to follow a purpose. If you want to process personal data, it always has to be for a specific purpose. So if your company wants to introduce AI saying, oh, just for anything, no. So you have to figure out specifically what you'd like to use it for. And that might prove more difficult than you think. The information and transparency stuff I've already mentioned. And also, how do we delete data from the LLM? I'll come back to details in a second. And regarding the form, meaning the formalities of introducing one, is the data protection impact assessment, because it's just, I won't go into detail, but whenever you introduce something that is innovative technology, then you're very likely to, as a company to have to do that, and just so you know. Okay, so, just a quick one. Personal data means data that refers to a natural person, that makes a person identifiable. And there is one German data protection authority in Hamburg that says basically, and I'm abbreviating this a lot, any data that is in an LLM is not personal, because it basically says it's been shredded into tokens, so none of this is the little pieces are not at all. They don't relate to any natural person. Even if it says names are shredded into bits and pieces, so you cannot relate to any person in it. So anything that comes out of it is newly produced. However, there is no European court judgment on this yet. Let's see how that works out, but at this point, I think we're in good company to agree with this. I do, personally. So But it leads to one question that I haven't really been able to wrap my head around really is, how do we, at this point, until now, we always talked about personal data. How does it relate to a natural person? And if so, with how much effort? Where is the borderline after which you say, nobody's going to figure out who is behind this? But now, with AI output, it is very likely that you produce an output that can look personal, but isn't. The AI, the model doesn't know who Frank Stiegler is, even if the name comes out. It's a parrot. It just hallucinates shit. So how do we work? How do we deal in the future? And this is more a philosophical question than legal, but I think it plays into it. How do we work with data that looks personal, but we know is hallucinated up? So again, to the process. So this is the image from before, and now we just go abstract to the four stages of no. So we have the 4 stages. We have personal data that's used for training. That might not be the case for you as a company if you want to use it. But we have personal data for input. For example, if you toss in a list of all your employees, asking for the ones that you should fire because they've been sick for too long. We have personal data output, obviously, if it revolves a name or names, and we have interaction data that might go to the provider saying, Frank Stiegler just asked for this. So, and we have to figure out how to do that. So it'll come back. This is a very data protection-centered thing, but basically the answer to whether that's okay is in Article 6. And I'll abbreviate this a lot. These are all the alternatives, the ways to do it. Consent, an explicit consent is very difficult to get, and you can't get it in most cases. So even from employees, from the entire staff, impossible to do, really. Everything else is also unlikely. The only thing that in my humble opinion, applies most of the cases is balance of interest. So you will end up asking, well, how's the risk for the data subjects whose data is processed here? And I know that whenever you have a US provider, it might be difficult because US transfer is difficult in general on this balance of interest basis, meaning Article 6, paragraph 1, letter F. But it's the best I can tell you at this point, unless you work with very sensitive data. That is always difficult. Health data, sexual orientation, union membership, stuff like that. So all I'm saying is you need to figure this out for all of the above steps, if you want to use personal data for training, for input, for output, and for interaction. So I'm saying it's very difficult to do, really. We talked about this, and also whenever you want to use an LLM to actually make decisions on people, you have a profiling problem too. And also you have to inform your data subjects about the involved logic that you have when producing this example. And that might prove quite difficult because you have an LLM whose result production process is intransparent. You just know it's been trained and stuff came out. All that you can do is basically say, well, we have an AI that we trained with this data set, but there are ways for companies to leverage or to mitigate the problem and take the AI out of the decision-making process. So if it's not just automated processing or if it doesn't have any significant effects, you're good to go. But if you do, that is more difficult and nobody has an answer to that yet. That I think we can omit. Oh, and this is also really interesting. When remember how you have the right to have your data, to get the data that is processed about you from a certain responsible person and that you can have it erased? Okay. Now, when it comes to AI, this is obviously more difficult because what data do you process about me? Or how did this data come about, especially in AI? Well, we have AI, kind of. And again, the profiling logic and everything. And erasing personal data might be difficult. Luckily, if you follow my opinion, saying there is no personal data in an LLM, you don't have to delete it from the LLM because there's none in it. But what about the interaction data that might be going to the provider? How do you get it out of that? Can you? So saying whenever you face that, you need to read the fine print and see if they allow you to do stuff like that. And okay, the last part was a little bit quicker. So we've made it, but what I have is a one page with learning points. And just for you to summarize it, and again, approach me at the party. So LLMs in general, difficult to monitor due to a lack of transparency when it comes to the result-producing mechanisms. The AI Act primarily regulates high-risk systems, so if you want just generation, it's usually okay. Only banks have to, or banks and insurances and public bodies, if you belong to that, you might have to do that, have to perform a so-called fundamental rights impact assessment. And when it comes to data protection, I think, and let's just see how it turns out, data in LLMs is not personally identifiable, but the interaction data might very well be. And it's very important to observe the legal purposes and basis of using LLMs. So basically, what do we want to use it for in this company and what do we not want to use it for? A data protection impact assessment can... Sure.
Would this mean in the end that no matter what, that you need just like this bureaucracy kind of stuff going on, or what?
The what, sorry?
Just like filling out the forms.
The bureaucracy, okay.
Do you not to fill out the forms over and over again?
Which forms?
This sort of forms, just like
Sorry?
Okay, maybe I try to explain the gates once more. Just like I see here a massive amount of more forms coming along our way.
There's documentation. You mean paperwork to do for companies?
Sure, and I don't understand that.
Yes.
This is my question, though.
But what is the question?
The question is, you're just like promising a little bit, just like calm down, because the paperwork still needs to get done. My question would be, can we get rid of that, of the paperwork?
I think no. I mean, it's not entirely. No, no. I mean, there's some stuff you need to document, and don't get me wrong. There is some accountability that creates paperwork that I think leads nowhere and helps no one. Am I okay with any documentation and paperwork that companies need to do at this point? No, I'm not. I'm really unhappy about some stuff that we people have to do. We companies. But can we just omit everything? No. But when it comes to a fundamental right impact assessment, just let's say for some reason you're a public body and you need to do that, it can be flanked by a data protection impact assessment. I think both documents are not something that will concern you unless you're a data protection officer or something, or an AI officer at your company, but just so you know, they're very similar and one can flank the other. And two more things, and then we can go into questions. When you have to give information on the involved logic when you process personal data, that can become really difficult because you don't know how an LLM produces its results. That's all I'm saying. I mean, there will have to be stuff to be done. Even supervisory authorities know that it's not easy to do that, and they all know that it's basically impossible, other than saying this is an LLM with this and that training set, but it's just one of the points where it creates tension between data protection principles and AI, because it's just not how AIs work. And obviously, if you have LLM run locally, then you have a much better way, much easier way of compliance. You can run it locally, you can control what goes in and out and what it's used for, but obviously it's more expensive. I mean, or usually I would say it's more expensive. And also, when you have like an offline model, you will have to replace it every so often, because otherwise it'll just collect a lot of dust and then it'll be difficult to get up-to-date results. I'm sorry, and in this following image I said to go out and create, but please pose questions. Questions. I'll go back. If we have I'm late. Do we have a couple of minutes for questions? We have -4 minutes. That's great. So I think that'll be 2. Like, come on, give me 2 questions. 2. There's a raising hand, please. Let's go quick. Sorry?
What's your take on facial recognition of
Public faces or public places? My take, difficult. In general, whenever you have specific cases, specific areas that are known to be dangerous, I think to some degree with a limited recording time should be okay. In general, and this is an AI thing, I think in general AI facial recognition, pattern recognition, I think is safer and better when it comes to data protection than the traditional recording itself, because nothing's recorded, but you make pattern matches, and when you have a match, you do stuff. I think that's better when it comes to data protection than the actual recording. It's included in it. It's a high-risk system by all means, so there's stuff that you need to do, but yeah, it's covered. And then one more. None anymore? Okay, one, please, scream. The question is, how do we? I think it was a mixed question. It's.
How did the Star Wars company manage to get this done?
So the question is
their
how
stuff cannot be used, basically.
yeah.
Is there a universal office that you can write to, or?
I think there is no universal office that you can just claim your trademarks with, but. There are ways, obviously, for copyright or trademark owners to go to big companies, let's say DeepSeek or OpenAI, and apply for things and say, we want our stuff not to show up here, just so that we're clear, and we will sue you if we do. So that is why, in many cases, you cannot generate images that have Star Wars in it or that resemble protected stuff. That's the way to do it. But I know there's tons of questions. Please hit me up. But we need to go. We needed to go 8 minutes ago. Thank you. Have a perfect party, and thank you for being here.